A courtroom can be quite a difficult place for a corrupt cop, and today we'll go through the most crazy encounters in which these evil police officers were owned and humbled in court.
Your actions are no reflection on the very many police officers who uphold the high standards that you upheld. That means that your total sentence is one of 6 years and 4 months.
Corrupt police officers often meet their downfall in the courtroom. Today we will look at cases where these corrupt officers received instant karma from judges after messing up badly. A corrupt South Wales police sergeant, Ben Cook, was on trial and is about to be sentenced by the judge after he plotted a string of crimes using police computer.
I have now to sentence you for the offence of theft of a key on the 4th of January of this year, attempted burglary of a dwelling on the 8th of January, burglary of a different dwelling on the 7th of February, securing unauthorised access to a computer material with intent to commit an offence between the 3rd and the 9th of February of this year, and the corrupt and improper exercise of police powers and privileges, again between the 3rd and the 9th of February of this year. At the time of all of these offences, you had been a serving police officer with South Wales Police for over 10 years and had been promoted to the rank of sergeant.
Cook had attempted burglary for £16,000 as he tried to steal it from the home of a deceased person. Just watch as the judge explains how it all unfolded.
On the 28th of December 2023, you and other officers attended a sudden death at a property in Pencoed. £16,870 was seized from a safe in the property for safekeeping. It was being saved by the deceased for his funeral. It was counted, and that count was recorded on body-worn video. Outside the property, you spoke to Miss Price, who was the deceased's sister. She was not allowed to enter the property and was not aware that the cash had been seized. 2 days later, her nephews told her that the money was missing, and so she reported it to the police, who told her that they had seized the money. On the 4th of January 2024, while the officer who was tasked to return the money was away, you went to Miss Price's home to return the money to her. You counted it in front of her, and she signed to acknowledge receipt of the cash. She told you that she was going to put it in her safe.
Imagine being a police officer for 10 years and then having the nerve to commit an atrocity like this. Things are about to get way worse, as you won't believe how he planned it all out.
You asked to use her toilet, which was situated next to the front door, and then stole the key to the front door, which had been left in the lock. Later the same day, Miss Price realised that the key was missing, and she replaced it with her spare key. Your personal vehicle was seen in the same street later that evening. On the afternoon of the 8th of January, using a mobile phone that you had obtained for the purpose, you telephoned Miss Price pretending to be someone named Thomas from the coroner's office. You told Miss Price that she had to attend the Prince of Wales Hospital in Bridgend urgently, as there was an issue with her brother's post-mortem examination. She was on a bus on her way to Swansea at the time, but she made her way to the hospital in Bridgend. You telephoned her a second time to check that she was still on her way to the hospital. At the hospital, Miss Price discovered that no one named Thomas worked there, and that none of the staff had contacted her.
Cook had carefully and ruthlessly planned the burglary, fully aware that Miss Price wouldn't be home. Shockingly, he carried out this scheme while she was mourning the loss of her brother.
You went to her address that afternoon, wearing black clothing and carrying a black Under Armour rucksack. You would not have been able to gain entry using the key that you had stolen, because the spare key was still in the back of the lock. When officers searched your home address on the 15th of February this year, they recovered a black Under Armour rucksack from your bedroom wardrobe and found Miss Price's missing front door key in the side pocket of that rucksack.
The corrupt sergeant's greed didn't stop there, as just a few days later he planned to do something even more shocking using the police computer system.
On the 6th of February 2024, you carried out searches on police computer systems into an address in Maesteg and the family that lived there. You did so because you had seen intelligence that suggested that £60,000 in cash was present at that address. At about 11:45 hours the following day, the 7th of February 2024, you went to that address. One of the occupiers, Miss Watkins, was at home and was in the shower. She heard 2 knocks on the door and then heard the front door being opened. When she opened the bathroom door, she was shocked to see you standing there dressed in full police uniform. You told Miss Watkins that you had a warrant to search the house due to suspected stealing. You had some paperwork, but she was not permitted to see it. You confirmed with her that there was no one else in the house. When Miss Watkins asked if she could telephone her husband, you said no and took the phone from her.
Officer Cook's actions were those of a criminal hiding behind a police badge. He used a fake search warrant to enter the home, and then what he did next was even more shocking.
You told her to remain sitting in the living room. You then went upstairs and located the family safe in the main bedroom. You brought the safe down and asked Miss Watkins for the key. She told you that she didn't know where it was. There was estimated to have been about £16,000 in cash in the safe. You told Miss Watkins that you had to take the safe away to get your colleagues to open it. You told her that you could not give her a receipt as she did not know the contents of the safe. You took a note of her mobile number and left at 12:31 hours. Miss Watkins immediately called her husband, Mr. Bailey. He came home, collected the key to the safe, and went to Bridgend Police Station to ask for his safe to be returned. At the police station, he was told that there was no record of police attendance at the address, and the matter was reported as a burglary.
Surprisingly, it didn't take a police investigation or complaints to hold the sergeant accountable. He incriminated himself.
At 18:34 hours that evening, you telephoned Miss Watkins and pretended to be PC Roberts from Gwent Police. Miss Watkins asked if you were the same officer from earlier that day. You asked if she wanted a crime reference number and if she had a pen and paper, and then you hung up. On the 9th of February this year, you telephoned the South Wales Police Anti-Corruption Unit and said that you wanted to hand yourself in as you had done something stupid. You claimed that you had been blackmailed and were in fear. When asked what you had done, you said that you had done a burglary, that you had been tasked to do it by persons that you didn't know but that you feared. You said that those persons had requested you to go to an address and remove something, which you did.
In an attempt to deflect blame, the sergeant fabricated a story claiming that he was being blackmailed. However, investigators quickly uncovered this lie.
You said that you had removed a safe with unknown contents and left it on wasteland near John's Lane. When you were interviewed on the 10th of February following your arrest, you claimed that you were being blackmailed because of your involvement with a female who you named. You said that a Bridgend-based organised crime group may have been responsible. You denied entering the property in my stake as a trespasser, claiming that you had been invited in as part of a setup and that you had been given instructions on where to leave the safe. You were interviewed about the first set of offences on the 29th of April this year. This time you said that you were being blackmailed because you had sent sexual photos of yourself to another man. Others had discovered your occupation and identity and demanded money from you, which you did not pay.
Eventually, Sergeant Cook did plead guilty to the offense he had committed, but only after having pled not guilty for the first 2 times.
You are not entitled to full credit. You will be given at least 20% credit for that offence and for the burglary and computer misuse offences. I have considered the sentencing guideline on totality. I will pass a sentence on count 2 that will reflect your overall offending and concurrent sentences for all other offences. The harm caused, which can include consequential harm, is high, given the dwelling house burglary that resulted and the likelihood of loss of trust in the police. First, punishment and deterrent are always important, because not only must police officers be deterred from misconduct, but the public must see that condign punishment will be visited on police officers who betray the trust reposed in them. Secondly, an incentive, usually but not necessarily money, inevitably increases the seriousness of the offence. It is those principles only that I have taken into account, as the offence and the circumstances of the offence in that authority are very different from those in this case.
The judge reminded the corrupt officer of the charges against him and outlined everything considered before delivering the sentence.
And so will not be taken into account a second time for those offences. For the theft of the key and the attempted burglary, I have borne in mind that you knew that Miss Price was mourning the sudden death of her brother. I have taken into account the effect of the burglary on Mrs. Watkins. Apart from the theft of the key, all your offending is aggravated by the careful planning of the offences, and that the offences were committed for financial gain. In mitigation and reducing the seriousness of your offending, you have no previous convictions. For over 10 years before you committed these offences, you had a positive character and exemplary conduct, even beyond that normally expected of a serving police officer, having received 3 commendations.
After delivering a long and impactful speech outlining everything the corrupt officer had done, the judge reached his sentence. But before that, she had a few more words for this tyrant.
Stand up, please, Mr. Cook. However, your actions are no reflection on the very many police officers who uphold the high standards that you upheld before January this year. For the theft of the key, if you had been convicted after a trial, the sentence would have been one of 3 weeks imprisonment. Less the 1/3 discount for your early guilty plea, the sentence is 2 weeks imprisonment. For the attempted burglary, if you had been convicted after a trial, the sentence would have been 2 years, 6 months imprisonment concurrent.
Sergeant Cook was sentenced to 6 years in prison. Due to his guilty plea, Cook received a much lighter sentence. He would serve 3 years in prison and then be placed on probation for the remaining 3. Now, while this cop was rightfully punished, the next one got a good lesson from this attorney.
Lane changes outside of the City of Bel Air Police Department jurisdiction. No, it's not my theory, it's the code.
If he has a dead body in the car.
In November of 2024, an individual named Trevor appeared in court after he was charged with carrying and a weapon. Judge David Fleischer started to lay the groundwork of the case.
Good morning, sir.
You're Trevor Flores.
Yes, sir.
Mr. Flores, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
Officers initiated a traffic stop after observing the defendant cross several lanes while failing to signal and almost causing a collision. Upon contact, the officers observed an odor of marijuana. The officers asked the defendant to step out of the vehicle and asked whether the defendant had marijuana inside. The defendant admitted he did have marijuana inside, as well as a firearm. During the search of the vehicle, the officers found a handgun in plain view on the driver's side floorboard, not in holster. And the officers also located 13 grams of marijuana in the passenger seat.
Now, this seemed like a very much open and shut case, with the suspect caught breaking the law. However, things took a drastic turn after the judge first questioned him about his license.
Forward with your case. Do you have a valid Texas driver license?
Sir.
Do you not?
I have a SR22 in place. My license was suspended.
Okay. You're not allowed to drive. Do you understand?
Yes, sir.
If I find that you drive, I will have a contempt hearing. It's possible you face another 6 months in jail. I'm going to have you sign an affidavit. I mean, I can't give you legal advice, okay? But as it stands, until you have a Texas driver license and liability insurance, don't drive. I'm also ordering you as a condition of your bond not to be in possession of any weapons as well. Do you understand? This is a condition of your bond. If I find that you have a weapon, I'm going to revoke your bond. I'm going to put you in jail. You will not get any more PR bonds. Do you understand, sir?
Yes, sir.
How old are you?
26.
What do you do for a living?
High school football coach.
Trevor did not have a lawyer at first, but a court-appointed attorney showed up hours later to defend him. The officer had no idea what kind of brilliance this attorney would bring to the case.
A little bit of digging
First
into, yes, and although we are still waiting for the bulk of discovery of the case, he's charged with unlawful carrying of a weapon following a traffic stop, and I've got a map that is kind of intriguing. I think you'll find just with the way it's drawn. But he stopped by an officer with the City of Bel Air Police Department, and may I approach to just show you this delineation. This is, but he's pulled over going.
I know the area well.
Northbound. He's pulled over going northbound on 610 as he, what is described as makes an unsafe lane change. So he's northbound on 610, wants to get on 59 to go southbound, is erroneously in the wrong lane going northbound. The officer says that she has observed him makes that unsafe lane change, and that lane change is outside of the City of Bel Air Police Department jurisdiction.
On short notice, the defense attorney presented a strong and compelling argument that even left the judge in disbelief.
Now, we have a particular statute that governs whether officers can have the authority to make a detention of someone when they are outside of their jurisdiction. And that's 14.03 of
Their
their
PD can still stop someone outside of Bel Air.
Well, not for, well, according to the code, it says a peace officer.
That would mean that any officer outside would never be able to do anything.
No, that's incorrect. There's a very limited exception, and that's what applies in this case. So it says a peace officer who's licensed and is outside of the officer's jurisdiction may arrest without a warrant a person who commits any offense within the officer's presence or view, other than a violation of Subtitle C, Title 7 of the Transportation Code.
The law stated that the officer couldn't make a traffic stop outside of his jurisdiction. Well, this was about to make the entire arrest illegal, as the initial stop, well, was illegal.
So generally, any offense that an officer sees, he can arrest that person or detain them, as the way the code uses that term, arrest. He can detain that person. But when it's for a traffic offense, that officer is required.
He's not arresting him for a traffic offense, though.
Well, that was the basis for the stop.
Sure.
But the way the code contemplates arrest, it's any, and that's defined in, I think, in chapter 15. But arrest, as contemplated by the code, includes detention. And so this officer doesn't have the ability, where that stop takes place, to make that detention. That officer could detain him if he saw him committing theft, could detain him if he saw him committing an assault, can't for a transportation code
But
violation.
he stops him for whatever reason it is, right? Comes up to the car and he smells.
And at this point, the entire case should be dismissed. There is no reason for the judge to rule any further, as the lawyer's argument is absolutely correct. However, Judge Fleischer chooses to debate with the lawyer once again.
So I think what's alleged is it's in conjunction with possession amendment. And for purposes of just this limited PC question, not my focus is solely the detention. I'm not.
It's certainly crafty. It's great. But he's not arresting him for the traffic offense.
Well, but I think we're looking at a limited scope of what arrest means.
I'd be saying that really, if he had committed an ag rob, right, or kidnapping, then even if he had kidnapped, like let's say he had a 2-year-old child in the car that he had kidnapped across state lines. Well, then, according to this, because he's in a different jurisdiction, then he couldn't arrest him on that kidnapping charge too.
If he saw a kidnapping taking place, the officer could arrest him under that code. But what he can't do is when there's a traffic code violation, we don't allow for example, the El Paso Police Department to come to Houston and then sit on the street corner and arrest people for traffic violations.
Even the judge applauded the attorney's efforts, and he realized he had made a strong argument. The officer who initiated the stop was clearly in the wrong, making this a classic case of the fruit of the poisonous tree.
Is a peace officer who's outside of his jurisdiction able to enforce the traffic code?
I know where you're going, and I've seen it before, but I'm not.
And we're looking at G1, Judge.
Where exactly did it occur anyways?
Let me see if I can pull up the address. We don't have like any discovery in this case, or how many dash cam or anything like that.
So what it says in there is 5600 610 northbound. And what's so curious about this is
That's still in Bel Air? Is it outside of Bel Air?
that would be outside of Bel Air too.
Look, I mean, I can't make that determination now.
Fair enough.
Number two,
Yes.
he's not arresting him on a traffic offense.
Well, and I think what the code contemplates when it says arrest, and I think there's case law on this, is that it includes the concept of detention as that's been, because I think when that code was written.
The judge initially tried to side with the officer, but the attorney quickly set the record straight with the undeniable truth.
So what I'm saying would apply as well, though. Like if he catches a 2-year-old kid, right, that's been kidnapped, by your theory, he wouldn't be able to arrest him on a kidnapping charge too.
Well, it's not my theory, it's the code.
If he has a dead body in the car, he wouldn't be able to do it.
Well, that's a legislature question. And I mean, but they wrote that.
I can't imagine that the legislature intended that. I think that they intended for a traffic, let's say for speeding, right? Or your tail light is out. Yeah, not to arrest in that respect. But he goes up to the car, smells marijuana, sees a gun in plain view. I can't imagine the legislature intended in that purpose.
And my position, of course, is that, this may be for a motion to suppress later down the line, and I think there's still plenty more to do in the case.
It's a freaking awesome argument.
But the idea
I love you.
is
Mr. Wonderful.
no right to
Right.
detain him.
Right? Really?
If this wasn't bad enough, this next police officer murdered his girlfriend and was sentenced to life.
The detective said, side chick, that's his baby mama. And there's a possibility that the boy is his son. I'm thinking we're supposed to be the good guys. He's supposed to be watching my back.
It is rare to see a police officer held accountable for their crime, but today we bring you some of the most shocking cases of corrupt officers who did the unthinkable and faced justice in court. Starting with a Border Patrol agent who made the most shocking decision of his life. On April 9th, 2018, Laredo police officers and Border Patrol agents were notified about a double homicide that had occurred in a park. The suspect was another Border Patrol agent, Ronald Burgos Avias, who was in his car when the officer stopped him. It wasn't until 2023 that this case was on trial, and the first responders were telling what happened.
The person that was using that car at the time was supposed to meet a Border Patrol agent at the Father Magnoble Park.
Okay.
The transmission that came in was the boyfriend's name was Anthony Burgos.
Okay.
When the radio transmission came up for Anthony Burgos, there was only one Border Patrol agent that was at that location with us. I had just seen him. I had never seen this person before. I see him. He's right near the car, and so I wave him over. I say, "Hey, come here." As he's walking up to us, the name says Burgos. So we look at the name. I'm looking at the name as he's coming over, and I'm just like, "Hey, what?" I think this is the person they just called over the radio, but they said Anthony, and I look at the first name and it's an R.
Ronald Burgos had just committed the ultimate blunder, and he was about to be taken to the cleaners by his fellow Border Patrol agents who wouldn't fall for his bluff.
Tells him, "Hey, what's your name, man?" And he says, "Ronald Burgos." And we're looking for Anthony Burgos. And radio transmissions are coming through, and so it's kind of getting a little hectic. Burgos approaches closer to Reyes. I'm walking next to him. I'm the only uniformed officer. So I'm right next to him, and he says, "Hey man, what's your name?" And then Burgos says, "Ronald Burgos Aviles." He only uses his last names. So then Rick's like, "What's your name, dude? Why are you not telling me your name? What's your name?" And he says, "My name's Ronald Burgos Aviles." And he says, You're not telling me your name. Do you have an ID or something?" And he's like, "No, I don't have an ID."
The Border Patrol agent had just arrived after murdering his ex-girlfriend, the mother of his child Griselda Hernandez, and his 1-year-old baby Dominic Hernandez. It was appalling to see how Burgos reacted after doing something as heinous as this.
Yes, so once I took the belt off, I put it behind his unit, and then I patted him down as the unit approached us. So I patted him down. I located a phone on him and a driver's license in his shirt pocket.
Okay, so, and what did you do with those two items?
I turned over the driver's license to Detective Reyes, and the cell phone, I put it with his property that I had already taken, which was his Sam Brown. I put it in the back of his truck.
The prosecutor moved forward to show the court the dash cam video of the arrest of the Border Patrol agent. As you can see, the corrupt officer had no remorse on his face.
What is it that he's doing in that scene?
He's wiping his arms. It looks like he's cleaning something off or.
What was it that he did right before he wiped his arms?
He licked his finger.
Officer Ronald Burgos was desperately wiping his arms and even sucking his fingers, trying to remove any trace of evidence. He had just used a knife to his ex-girlfriend and their young son, with the evidence plainly visible to everyone.
man. Oh yeah, he could have just told me straight up, man, instead of making me go through it. Embarrassing, big ordeal.
As the trial progressed, witnesses came forward, and amongst them was a key witness, another Border Patrol agent, Francisco Lara, who made a shocking revelation.
I look south and I see the silhouette of the young woman. So I completely forget about Mr. Burgos and I start running towards the victim.
See the victim?
As soon as I see the victim, I approach and I start yelling. Like, señora, despierta, estás despierta. Ma'am, wake up. Because at this time, all I see is blood. I told my trainee, I call him Schmitty. I like, Schmitty, is that what I think I'm looking at? And I see the silhouette and I immediately start running towards her. And that's when I tell him, like, I start yelling at her, estás despierta, are you awake? Do you have any gloves? He's like, no, I do not. So I say, I don't have any gloves. And I asked my trainee, Schmitty, do you have any gloves? And thankfully, being the great agent that he was, he did have a pair of gloves.
Burgos had devised a strategy, as moments after his ex-wife and son, he ended up calling the cops, claiming that a murder had been committed. Officer Lara explains how he tried to con everyone.
And I immediately check for a pulse. I don't feel a pulse. I look at my fingers and they're covered in blood, because I checked her neck area. So I don't feel a pulse. So I immediately see her left wrist. It's facing up. I check her wrist, and again, I do not feel a pulse. Right away, I told Mr. Burgos, sir, I think she's 10-7, which means that she's dead. And he's like, yeah, it looks that way. So I'm radioing everything into our station, and I'm letting him know what I'm seeing. At this time, he's standing there. Not really, the supervisor normally takes control of the situation and radios in everything to the station. Once again, he's quiet. I'm the one relaying everything that I'm seeing to the station. I'm processing everything in, I'm taking it in, and I'm telling them what I'm seeing. And right away, I start telling the camera operator to start scanning the river. I tell him, scan the river, see if you see anybody going back.
Burgos had used his police training to carry out the crime in a bushy area, where Griselda ended up having 27 stabs, and baby Dominic had received 2 as well.
Next to the victim, I check her. Mr. Burgos is standing over here I guess on the other side of her. So I tell him she's 10-7, which means she's dead. Radio everything in. I told base 2, I think she's dead. They tell me take a step back, trigger the crime scene. So before anything, I told my trainee, go to the gate and open it for the paramedics. He takes off. So before I take a step back, I'm surprised to see so much blood. So I grab my head and I'm like, where is all this blood coming from? I take a step back. At the time he picks her up, I could see the shadow of her face.
Officer Lara, a junior at the crime scene, could not believe his eyes as he watched his senior, Officer Burgos, handle the victim with shocking indifference and remained completely unfazed by the brutality of his action.
I get a phone call from my team leader. My team leader tells me, hey, we already activated the Border Patrol unions, the lawyers for you. Before you make any statements, we already got lawyers. And I'm like, we already made our official statement. He was surprised. He's like, oh, you did? I'm like, yes. He's like, before he hangs up, he's like, just so you know, there's a rumor saying that the dead woman is Burgos' side chick. I'm like, all right, 10-4, let me call you back.
It wasn't until detectives began investigating the murder that Officer Lara realized that the woman was Burgos' ex-girlfriend and the mother of his child. This revelation left him in a deeply emotional and shocked state.
We just heard her.
Going to question answer basis, Mr.
I'm good, sir. Thank you, Your Honor.
That is exactly how everyone in the court felt, and we can only imagine the condition of Griselda's family. It turned out Burgos had committed this horrible act just because he was refusing to pay child support. Finally, after listening to hours of testimonies and getting evidence, the jury reached a verdict.
In cause number 2018 CRA 852D1, in the case of the state of Texas versus Ronald Anthony Burgos Aviles, the jury has returned a unanimous verdict. I'm about to read the verdict of this jury on punishment as to count number 1. Special issue number 1 on count 1. Whether there is a probability that the defendant, Ronald Anthony Burgos Aviles, would commit criminal acts of violence that would constitute a continuing threat to society. Answer, yes. Signed by the foreperson. Whether taking into consideration all the evidence, including the circumstances of the offense, the defendant's character and background, and the personal moral culpability of the defendant, there is a sufficient mitigating circumstance or circumstances to warrant that a sentence of life imprisonment without parole rather than a death sentence be imposed. Answer, yes. Signed by the foreperson of the jury.
The jury unanimously decided that Burgos would receive life imprisonment instead of the death penalty. Now, many might argue that the death sentence would have been a more fitting punishment for such a heinous crime.
You heard me announce the verdict of the jury with regard to both counts of this indictment. It is now my job to sentence you in accordance with that indictment, with that verdict. Do you understand that?
Yes, sir.
After being found guilty by this jury of 2 counts of capital murder, and after giving us the verdict that they have just announced, it is my job now to pronounce sentence. As to count 1 of capital murder, and as a result of the sentence of the verdict of the jury, you will be sentenced on count 1 as to capital murder to a term of life without the possibility of parole. As to count 2,
Burgos was immediately transferred to the jail and is guaranteed to die there. The shocking encounter truly left everyone speechless, and it is even more saddening that it took 5 years for justice to be delivered to the poor victims' families. Well, nothing might top the brutality shown by this officer, but this next tyrant made another huge mistake.
Nothing in his hands, and he was shot twice
In 2011, during a routine traffic stop, Officer Osvaldo Villarreal fatally shot an unarmed Benny Herrera. The victim's family filed a lawsuit, but it took 5 years for the case to reach pretrial, as Villarreal's attorney attempted to argue for qualified immunity.
It's a tragic case, there's no question about that. But Officer Villarreal was required to make a split-second life and death decision.
What required him to do that? It doesn't look to me as though he was the initiator.
The fact that Mr. Herrera, first of all, he had been acting erratically before the shots were fired, moved from a place of relative safety on the shoulder of the road into the roadway. He was skipping.
But if we're talking about Officer Villarreal, how much did he know about the prior behavior?
He saw all of that.
I have to say what you're saying is inconsistent with what I saw on his own camera. That is to say, the point at which he began to get close enough to see anything. Some of that earlier stuff was on the other camera, but not on his.
Officer Villarreal had shot the poor suspect only a second after he asked him to take his hands out of his pocket, and sadly, the attorney was defending this monster.
All at one point, his camera was turned on, but
His
he
camera
testified.
his camera was turned on well before he got to the scene.
He testified in deposition that he saw Mr. Herrera on the side of the road, and then he saw.
Well, he can testify to what he wants to testify to, but I want to tell you what I saw on his own camera tells me that the early part of this he did not see, could not see. That was his intention, you say?
That was his intention, and that's in his deposition.
Again, I'm relying on what's on the videotape, and now this is in Officer Villarreal's car. I hear him say, "Take your hand out of your pocket," and I hear the gunshot almost simultaneously.
Exactly.
They cannot be separated by more than a second.
And that's exactly the time period when Officer Villarreal had to make his decision.
Shockingly, even the police department cleared Officer Villarreal's conduct, but the judge had another idea.
Here, Mr. Herrera was arguably complying with Officer Villarreal's order to remove his hand from his pocket at the time that he was shot. So how is it that we determine that we should grant qualified immunity?
Because qualified immunity allows for police officers to make mistakes. It allows for the possibility that officers will make mistakes in judgment, and that's exactly what happened here. Officer Villarreal had a choice to make. Do I wait and see whether there's something in the hand that could kill me, or do I shoot? And he made the decision to fire. We know with the benefit of hindsight, obviously, that was wrong.
Is it safe?
The officer was about to face the consequences of his actions as the judge unanimously decided that his qualified immunity should be tossed.
As long as the historic facts are undisputed, the question of whether or not Officer Villarreal's actions were reasonable is a question of law. It's not a question that you give to a jury, because we don't want juries second-guessing the very, very difficult life and death decisions that officers have to make.
I agree, but at this stage, again, this is not an argument to a jury. For us to even have jurisdiction over this case, we take those facts. Yes. You're saying that as a matter of law, the shooting here was legal.
Yes, it was objectively reasonable. Well, not just those facts. Officer Villarreal knew that Mr. Herrera was a suspect in a domestic violence incident. Okay. He knew that he had a gang affiliation, that he was on parole, that he had a warrant out for his arrest. All of those things factor into
on parole. I don't remember on parole. They said
on parole, yes, and there was a warrant out for his arrest.
What do we know about what Officer Villarreal knew with respect to whether he was armed?
We know that dispatch told Officer Villarreal and Officer Miali that Mr. Herrera was not known to be armed.
The attorney continued to make bizarre and illogical arguments, but the judges swiftly rejected them, firmly believing that the officer should at least stand trial for his actions.
No, sir, the suspect had refused to put up his hands, had threatened the officers, and an officer believed that she saw something in the suspect's hand, saw him move his arm, and was worried he was going to shoot her. But yet we affirmed the denial of qualified immunity in part because the suspect had not brandished a weapon or spoken of a weapon.
I do recall that case, Your Honor.
The domestic violence incident was over.
Yes, and there...
So, I mean, how does that strengthen your case? I mean, that was, if you're arguing that it was an ongoing domestic violence, so...
it wasn't an ongoing domestic violence incident, but it was a warrant out for his arrest, that he had known gang affiliations, and all of those things factor into, am I afraid of this encounter, or do I think that this is going to be a perfectly safe encounter? And everything that they observed, or a lot of the things that they observed, heightened the situation to a point where it was objectively reasonable for the officers. Nobody disputes that, for example, that it wasn't objectively reasonable for the officers to have their guns out. They were going to do a felony stop. Domestic violence under California law is a felony. So they had their guns out. There's some question about whether or not there were other alternatives available. Well, in the split second that decision had to be made, you couldn't put the gun down and pick up a baton. You couldn't put the gun down and pick up a taser, assuming that Officer Villarreal even had a taser. I think there's testimony in the record that he didn't have a taser available to him. He had to make a decision based solely on what he knew at the time. And it's easy for us to sit in hindsight and say, well, Mr. Herrera didn't have a gun. Mr. Herrera didn't really pose any
I don't think
threat.
anyone here said that one time.
No,
I think what we're focusing on, again, the narrow standard we have to deal with here. And that's what we're dealing with. This is not a jury trial. This is not summary judgment. It's a very limited thing. No one here is raised about the fact he didn't have a gun.
I understand. The trial court did.
The plaintiff's attorney stepped forward and presented compelling arguments that further solidified the need for the officer to face trial, strengthening the case against him.
And that the officers perceived a heavy object in that pocket. That's...
First part, yes. Second part, a little less clear. But I think there's no question that he had his hand in his pocket.
Well, and both officers said it looked like he had something heavy in his pocket. Okay. All right. And then just before Mr. Vial opened fire, Mr. Herrera rapidly removed his hand and moved quickly, it seemed like, toward the officer's car. Why isn't that enough?
Well, because sticking on the undisputed facts, the officers had no information that any weapon was involved in a crime. They were specifically told he was not known to carry weapons. He had nothing in his hands, and he was shot twice and killed. We specifically asked the officers about their training, and they conceded, which is included in the cites in our brief, that deadly force is a last resort, only to be used in the direst of circumstances, only when no other reasonable measures are available. And
finally, the judges reached a conclusion and gave one last shut-up call to the defense attorney.
If everything goes bad for your client, that is to say, if we send it back, if the jury says no qualified immunity, and if the jury comes in with an award of some amount of damages, will your client pay those damages out of his own pocket, or will it be paid by his employer?
It should be 99.9% of the times it's paid by the employer. I don't see why it would be different.
Well, by statute, California statute says it's paid by the employer unless they're punitives.
Yes,
isn't that right?
That was what I was going to say.
So that doesn't say 99%, it says 100.
Well, I was going to say, unless there were
punitives.
If there were punitive damages, the city would have the option of deciding whether to pay those punitives.
This next sheriff thought that he could have his way, but was instantly humbled by his judge.
I feel like I'm being very much bullied into doing something that's not right. And I want this court to know that Todd Pate holds himself responsible for everything that he did.
Police officers often face the heat of justice in courtrooms, and today we will be looking at some of the best moments when corrupt cops were held accountable by some honest judges. We begin with former Breckenridge County Sheriff Todd Pate, who is far from a typical defendant. He is facing charges of assault, second offense DUI, criminal mischief, and leaving the scene of an accident.
This time is it your desire to change your plea from not guilty to guilty?
Do I have to answer that yes or no, or can I make somewhat of a statement that's
that is a yes or no answer, sir.
Will I have the opportunity to say anything further?
If it is your intention to change your plea from not guilty to guilty, certainly you'll have an opportunity to make any statement. But if it is not your intent to enter a guilty plea at this time, then I'm going to set your case for jury trial, and you're going to stop wasting my time and everybody else's time this afternoon.
Ma'am, I'm not trying to waste your time.
Then is it your intention to enter a guilty plea at this time or not, sir?
No. Why am I wasting your time?
4 people were hurt in an accident that Todd allegedly caused while driving a car. Shockingly, he fled the scene. When arrested, his blood alcohol was nearly twice the legal limit.
Why am I wasting your time?
Mr. Chambers, what is the Commonwealth's position at this time, sir?
Your Honor, we would move to revoke the defendant's bond at this time.
Let's get back on the record and see if we can sort this out. At this point in time, what is Mr. Pate's decision with respect to his guilty pleas?
So I believe I'll just let him answer that question if it pleases the court.
All right. So, Mr. Pate?
Can I say a few things, or?
I need to understand what it is that we're doing here today, Mr. Pate.
Yes, I had every intention of coming in here today and entering a guilty plea. It's difficult for me to enter a guilty plea for a lot of reasons, and I don't want this court to think that I am trying to minimize any responsibility that I had in this situation that occurred.
The controversy deepened as he disputes the assault charge, thinking it was added solely because of his role as a sheriff and his decision to reject a plea deal offered by the prosecutor.
Like I'm being very much bullied into doing something that's not right, and I want this court to know that Todd Pate holds himself responsible for everything that he did. It's hard for me to lay down and plead to felony charges that don't apply.
Is it your intention today to enter this guilty plea?
And if I could address...
This is either a yes or no. Are you going to enter your plea or not?
I guess everybody thinks it's funny.
With credit for time previously served, he eventually entered a guilty plea and accepted a sentence of 75 days in county jail. Now this case was intense, but the next courtroom showdown will leave you questioning everything.
We've got a complaint of you out here holding up profanities. Okay. I'm not going to tell you again. You have your ID on you? I don't have my ID. Your hands right here.
In December of 2018, a YouTuber named Otto the Watchdog held several signs while standing on public land. As cars drove by, many waved and honked in support. What started as a peaceful demonstration was about to take a dramatic turn.
Sheriff's Office dispatch.
Hi, there's some people out here at Interstate 30 and South Elm that have some very offensive signs.
Officer Johnny Clark led the Roy City Police Department's response to Otto's location, as officers from the department were dispatched to the scene.
Where's Johnny with the other one? Should be right over here. Thank you. Yes. Some guy holding up a sign that says shit is f***ed up and stuff or something. Still in office. How are you? Well, I was doing just fine until just a minute ago. I've already heard you say a cuss word once. So. What do your other signs say, sir? Sir, what do your other signs say? What am I doing? Okay, can I see your other signs? No, leave my seat away. Sir, we've got a complaint of you out here holding up profanities. Okay. Okay, if you don't let me look at your sign, I'll take you in custody for disorderly conduct. I'm not being disorderly.
Otto was soon approached by officers who confronted him about his sign. Sergeant Dial was clearly displeased with Otto's firm refusal to consent to search or seize his property despite their demands.
I'm not being disorderly. Okay. I'm not going to tell you again. All right? I don't consent to any searches or seizures. Okay. This is offensive to people that are driving by. And families that are driving by. Yes. Yes, it's disorderly conduct. What's the penal code? It's disorderly conduct. Can you read that to me? It's disorderly conduct. Okay. You have your ID on you? No. Okay. Now you're failing the ID. I don't have my ID.
The tension reached a boiling point when the senior officer angrily punched Otto's signs out of his hands. Everyone was shocked by the aggression, even Officer Clark.
Roll over. Since he's failing the ID, take him to jail for disorderly conduct. When we're here answering a complaint and you refuse to identify yourself, that is a crime. When you're displaying these signs and people are calling because it's offensive to them, that is another crime. So yes, you have committed a crime. You've committed two. You didn't warn me. We don't have to warn you. Ignorance of the law. I asked you politely to see your signs and you said no. I don't consent to any searches or seizures of my property or my person. I'm not going to take it.
In a powerful act of passive resistance, Otto laid down on the ground, showing that the arrest was unlawful. His message was clear, that he wouldn't resist, but wouldn't comply either.
Is that your cell phone and tripod? If it's not, I'm going to leave it sitting here. If it is, I'm going to take it and put it up so somebody doesn't steal it. But if you want to act this way, I'll leave it sitting here and let somebody steal it. Why would you do that? Okay. We don't know whose stuff that is either. I have a question. What am I being arrested for? The officer just explained. Now's not time to ask questions. Oh, it is the time to ask questions. You know what? Nobody even asked me to identify. All he did is ask me if I had ID, and I don't have ID. Let me explain something to you, young man. We're not holding court on the side of the road with you. Okay? Well, you're arresting me. I just want to know why. I just want to know why I have handcuffs. Any questions you have, you can ask the jail, or you can ask the court. You gonna get up? I can. Okay. Roll back over and I'll help you up. I'm not sure if I can do that either. I would like to see your supervisor right now before you assault me any further. I am being assaulted. I have not committed a crime.
When the officer threatened to leave Otto's camera at the scene for anybody to take, he then worsened the situation.
I have not committed a crime. Get up. I have not committed a crime. I can't get up. You're hurting me. You are hurting me. Then get up. I cannot get up. Then get up. I can't get up like this. They lift you up. I'm trying to get up. Now, please get up. Well, assist me up instead of trying to. We're trying to help you up. Lift you up. I'm trying to get ass. Yes. I've seen the game before. Roll up to your knees and they will assist you up. Roll up to my knees. I'm a fat man. Okay. Help me to my knees. We already have one. Well, help me again. Now they'll lift you straight up. On your feet, stand up. Okay, help me up. I have committed no crime. I have committed no crime whatsoever. Get my equipment. That's not yours. Remember, I asked you earlier. Come on. So you're going to leave my shit on the side of the road. Get my equipment. Get my equipment. You dude, I'm asking for you to get my... Hey, I've committed no crime. Unlock your car, please. No crime.
They want to turn this phone off.
I ain't turning nothing off. I'm going to leave it right like that, put it in evidence.
According to the Texas Penal Code, people are not required to identify themselves until they are under arrest, despite the officer's claims that Otto was held for failing to identify himself.
I asked him if it was his, he didn't want to talk.
I heard it all.
Yeah.
Okay. You know where his car is?
Somewhere up there. If I had to bet.
Still under arrest for failed ID.
I was under arrest, and then I ID'd, as the code says.
No, the code says when you're legally detained, you're required to ID yourself. You did not.
It specifically says arrested. Okay. I didn't do nothing.
What's your phone number?
I didn't do nothing.
In response to this injustice, Otto sued Officer Short and Sergeant Dial, claiming they had violated his First Amendment rights and engaged in malicious prosecution. Otto's attorney expertly undermined the sergeant's case throughout the deposition, leaving him completely vulnerable and unable to justify his conduct.
As I explained earlier, one, it was an officer safety issue because I don't know what the signs are made out of or what they were. And they could be used as a weapon. And secondly, we were still investigating whether a crime had been committed, and he was unwilling to show us what the other two signs, or what the sign says, other than what we could see.
Did you believe that Mr. Knowles had an obligation to give you those signs?
What do you mean, an obligation?
Did you have the right to see those signs?
Well, it's part of our investigation.
Did Mr. Knowles have the right to refuse showing you the signs?
Anybody can refuse anything.
Objection form.
Why did you hit the sign so hard?
Objection form.
Sergeant Dial should have a firm grasp of the law after 11 years on the police force, yet his ignorance was clearly evident throughout the deposition.
I don't know what your definition of hard and soft is, and that was 5 years ago.
How do you define hard and soft? You can use your own definition, please.
In regards to what?
The level of force that you applied to the signs.
I mean, I don't know how I would describe hitting a sign soft or hard.
Why didn't you use less force when touching the signs?
Objection. I didn't know I used too much force.
Could you have used less force when touching the signs?
Objection form. In regards to what? I mean, what was the amount of force that I used?
You said earlier that you conducted an investigation after you arrived on the scene that day with Knowles. What were the results of that investigation?
In regards to what?
In addition to violating Otto's rights under the 1st, 4th, and 14th Amendments, Sergeant Dial's utter lack of understanding about disorderly conduct laws was painfully clear.
Did you find anything during your investigation that caused you to arrest Knowles, that caused anyone to arrest Knowles?
Through our investigation, we determined that disorderly conduct had been committed.
How did disorderly conduct get committed?
Due to the verbiage that was on the signs, and we had received complaints.
His ignorance was a clear sign that he was completely unfit for the job.
If you received the same complaints, and those signs had said something different, would Knowles have been arrested?
The same complaints in what? Because the complaint we had was, it was vulgar and offensive.
What I'm asking you is, if the complaints were the same, but the contents of the signs were different, would Knowles have been arrested?
Objection form.
What if the sign said Blue Lives Matter?
How is Blue Lives? There's nothing vulgar about Blue Lives Matter. There's no profanity in Blue Lives Matter.
Are you saying that if the sign said Blue Lives Matter, Knowles would not have been arrested?
I'm telling you that based on the complaints that we received that day, a guy telling me that he was offended by the profanity and vulgar that was being used in the signs.
Objection, non-responsive.
Sergeant Dial said the arrest was initiated because the sign hurt someone, although he could not name any laws that Otto had broken. It is clear he needs to read up on the Constitution before making any more decision.
If the complaints were the same, but the sign said Blue Lives Matter, would Knowles have been arrested that day?
Objection, son. There's no vulgar or profanity in in the verb or term, the verbiage or term Blue Lives Matter.
Do you think anyone that says a bad word publicly should be arrested?
No.
Why not?
Did someone complain on them, or are they just out there just throwing a fit? No complaints. I mean, there's several reasons why we would not arrest someone. I mean, if nobody finds it offensive, then disorderly conduct's not met.
So if the language on the signs had not offended someone, Knowles would have been arrested, or would he not have been arrested?
So you're telling me we didn't receive any calls and nobody complained to us? Would we have arrested Knowles that day?
Correct.
No, we wouldn't not have.
During the deposition, the lawyer took over the situation by interrogating Sergeant Dial incessantly. However, the true surprise was still to come.
What specifically did Clark say to you about Knowles' prior disorderly conduct?
He was explaining it to Knowles that as I'm walking up, he's explaining it to him that, look, I've already heard you out here cussing at people.
So he was talking to Knowles, not you?
That is correct.
Did any motorists complain about the prior alleged profanities that Knowles said before you arrived?
Well, the one gentleman told me about the signs, and regarding what the people on 911 called in about, I do not recall that.
If anyone complained about verbal language and you didn't hear any allegedly profane verbal language from Knowles at the scene?
I did not hear it, but I heard Clark explaining to Knowles that he has already witnessed it or observed it himself.
As he prepared to ask the last question, the attorney knew it would leave the officer completely speechless, and it did.
Do you know one word of profanity that Knowles said?
No, I do not.
And you are not aware of any person that was offended by what Knowles said?
No.
When the sergeant unintentionally acknowledged that the arrest was based only on the placard's content, he immediately exposed the constitutional rights infringement and dug his own grave.
Were you offended by the contents of his signs?
No.
Why did you think they were offensive?
The sergeant's errors mounted as the attorney focused on the First Amendment infringement, underscoring his total ignorance of the law.
So you would arrest somebody if a citizen complained about vulgarities?
Objection, phone. So a citizen made the police department or dispatch aware that they had used profanities and vulgarities and were offended. Would I arrest someone?
That's what I'm asking.
Yes.
Have you arrested more than 5 people in your career?
I believe that would be an accurate statement.
Have you observed more than 10 arrests in your career?
I'd probably say I have observed more than 10 arrests in my career.
It is startling that a 10-year police veteran was unaware of the First Amendment. This then calls into question the caliber of law enforcement training. What sort of personnel are we teaching to serve and defend?
Have you observed more than 25?
That I don't know.
Have you observed more than 30 arrests in your career?
I don't know.
Do you remember any specific details about your training regarding First Amendment rights?
No, I do not.
Are you saying that you don't remember one word from your training regarding First Amendment rights?
Objection. That is correct. We went over the elements of the Constitution, and I believe the First Amendment is part of the Constitution.
But specifically the First Amendment, you don't remember?
Correct.
Do you remember how long you spent studying constitutional rights?
No, I do not.
Have you had any training related to constitutional rights since you became an officer?
I do not recall.
It is baffling that someone in such a high-ranking position could exhibit such a glaring lack of knowledge. How can we trust officers with such critical authority when they don't even understand the basics of the Constitution?
What topics have you been trained on since you became an officer?
I don't recall all of them.
Name one.
Accident investigation.
Anything else?
Well, I'm sure there's others.
Where did you receive the training regarding constitutional rights in 2007?
When I was in the police academy, is that what you're referring to?
I'm referring to the training that you referred to, that you received in 2007 regarding First Amendment rights.
The Collin County College Police Academy.
And who trained you in constitutional rights?
Could not tell you.
Because you don't remember?
You're asking for the instructor's name? No, I do not remember the instructor's name.
This is the result of insufficient instruction on the First Amendment and fundamental rights.
Do you remember anything about the protections provided to citizens by the First Amendment?
No, I do not.
Are you aware that the First Amendment gives citizens what's known as the freedom of speech? Have you heard of the freedom of speech?
I have.
What do you think that means?
Interpretations are a dime a dozen, but basically someone can speak freely.
Following the deposition, the city was compelled to settle, and Otto was given $25,000.
First Amendment protect a person from being arrested because of what they say.
Objection form calls for legal conclusion. Do I answer it? Answer. I think at times it may.
Has the police department provided you with any subsequent training on constitutional rights since you've been an active officer?
I do not recall.
Have you received any training, guidance, or instruction regarding First Amendment rights while you've been a police officer?
Objection form. In the police academy, I know we went over the constitutional rights.
But anything since then?
I do not recall.
Moving on, this corrupt sheriff thought he could violate the court's rulings, but was instantly proven wrong.
Today is that day. You are not the law. You don't interpret the law. You don't enforce the law. You're not above the law.
Corrupt cops often believe they can get away with their abuse of power, thinking their badge will shield them from justice. Today, we will go through the jaw-dropping cases when the very system the cops manipulated turned against them, serving brutal karma right in the courtroom. On June of 2023, the Indiana State Police launched an investigation into Clark County Sheriff Jamie Knoll. They found that he had embezzled more than $5 million in taxpayer money. Now, Sheriff Knoll was instantly relieved of his duties and accused of 25 offenses. This was just the first step toward his downfall as a corrupt cop.
Date of birth? 12/18/70. And that will make you how old? 52, sir. And the last 4 digits of your social security number? Mr. Knoll, Special Prosecutor Pearl has charged you with 15 counts of criminal conduct. And I'll go through them. Count 1. Corrupt business influence is a level 5 felony. It would indicate that pursuant to Indiana Code 35-44-1.1-2-1, that on or about a period of time from November the 9th, 2018 and August the 16th, 2023 in Clark County, state of Indiana, you did knowingly or intentionally through a pattern of racketeering activity acquire or maintain, either directly or indirectly, an interest in or control of property or enterprise contrary to the form of the statute in such case made and provided. Count 2, theft, as a level 5 felony. You then personally sold said Hellcat for $83,000, $83,716. Count 4, theft is a level 6 felony under Indiana Code 35-43-4-2A.
Numerous charges were also brought against Jamie Knoll's daughter, Casey, and his wife, Misty. It is truly remarkable to see how the sheriff was able to engage in such corruption and yet maintained his position in the agency for such a long time.
On or about August the 16th, 2023, in Clark County, state of Indiana, you did knowingly or intentionally alter, damage, or remove any record, document, or thing with the intent to prevent it from being used, produced as evidence in any official proceeding or investigation. That being, you factory reset your phone upon the arrival of the Indiana State Police on your property. You, in your capacity as Clark County Sheriff, public servant, did knowingly or intentionally assign to Rodney Walker, an employee under your supervision, duties that were not related to the operation of the governmental agency that you serve, that being sheriff, assigned Walker duties on your personal property, rental properties, father-in-law's property, pole barn, and property of the Utica Fire Department. Count 11. And count 15. Official misconduct is a level 6 felony. It would indicate that between November the 9th, 2018 and December the 31st, 2022 in Clark County, state of Indiana, you, a public servant, that being Sheriff of Clark County, knowingly or intentionally committed an offense in the performance of your official duties, that being ghost employment as Sheriff of Clark County relating to Brent Fisher. Mr. Knoll, the first 3 counts are level 5 felonies, which have a range of imprisonment from 1 year to 6 years, with the advisory sentence being 3 years and up to a $10,000 fine. Counts 4 through 15 are all level 6 felonies, which have a range of imprisonment of no time in jail treated as a misdemeanor to 2.5 years at the Indiana Department of Corrections, with the advisory sentence being 1 year and up to a $10,000 fine. Do you understand what you've been charged with?
Yes, Your Honor.
Do you understand the potential penalties?
Yes, Your Honor.
The next question is, usually you intend to hire a lawyer, but you obviously have counsel seated with you. I need to tell you, you have a right to a speedy public trial by jury in this county. You have the right to face all witnesses against you, severe question and cross-examine these witnesses.
Jamie sat through the proceedings with a complete lack of guilt as the judge systematically read out the 15 counts against him during the hearings. The tension was high in the courtroom as the state attorney made a strong case for his detention without bond. Despite the gravity of the charges, the judge decided to grant bail, but little did he know that this would turn out to be a serious mistake.
His passport to you by noon tomorrow, and then you will surrender it to the court by 4 p.m. next Monday, because it's my understanding the court here is closed tomorrow.
Yes, Your Honor.
He will surrender all firearms except one shotgun of his choice to Indiana State Police. Being from the country, or as Mr. Wilder said, Washington County, I keep my shotgun with double lock near me, along with my .45. But I think one shotgun for personal protection is appropriate for him to maintain. Will not leave the state of Indiana without permission of the court, and they'll post $75,000 in cash. Mr. Knoll, you wanted him released without posting any bond, but it's a unique case, and if you don't like my decision, I'm happy for you to appeal it. It won't be the first time you've appealed me, and the Court of Appeals told you I was right, so I'm happy for you to accept that challenge if you so please. I'm not going to have you report in.
After delivering the announcements, the judge made one thing unmistakably clear, leaving no room for confusion or misunderstanding.
You keep one shotgun only. try to deceive me, you will not like the consequences. Understand?
Yes, Your Honor.
Okay.
And then, Judge, the issue of return of all other items seized, we can just take them in another hearing.
Well, it wasn't set for today, so
No,
yeah, we'll deal with that at another time. I assume now that everything's going to be unsealed, there'll be a lot of new things brought before the court that
yes, Your Honor.
we'll address in due time.
Thank you, Judge.
Anything else?
No, Your Honor. Nothing else from us, Judge. Thank you.
All right, we'll be off record. Thank you all.
Although Jamie was first granted bail, however, his freedom was quite short-lived. When he violated the judge's order, police raided his residence in March and found a stash of hidden weapons. When the judge was called back for another court appearance, he was clearly outraged and did not hold back this time, delivering an uncompromising reprimand.
I told Mr. Knoll, don't do anything stupid. Do not try to deceive me, defy me. You will not like the consequences. Today is that day. You are not the law. You don't interpret the law. You don't enforce the law. You're not above the law. I find that you are in contempt of this court. Take him into custody. No, that's enough. I'll find you guys in contempt for disrupting the proceedings, and you'll be there right there with him.
Ironically, Jamie Knoll's appearance in A&E's 60 Days In, a series that exposes the inner workings of law enforcement, ended up on the wrong side of the court. During sentencing, the judge made an intentional point of mentioning his feature in the series, highlighting the sharp fall from grace of the former sheriff.
Now, what is an appropriate sanction? The question is, I can sentence him up to 180 days without a trial, or I can sentence him to a day, or I can release him. You know what I think the answer is? 60 days in. That's what I think the answer is today. Now, Mr. Wilder.
Yes, Your Honor.
Or Mr. Boyles, I apologize, Mr. Boyles, your lead. Before he is released, I'll take your suggestion. I want an independent individual to scour that household to determine that there's no further weapons. I find that Mr. Ertle's original argument that he was trying to make that I sustained, an officer of the law, every time I go into court, I hear, I didn't know it was there. I didn't know it was there. It really did. You've heard that a million times. You've heard it a million times, and yet you still take them into custody, would be my guess. Every officer in the world has heard, I didn't know it was there. It's my friends. I'm not buying it. It was your burden. It's your responsibility. And today, the court will enforce that. Take him away.
Even though Jamie Knoll received a 60-day term, his legal issues are far from over. He is currently facing 31 felony charges, and the outcome of his trial might mean a long jail term. Knoll's once powerful position has collapsed into an abrupt fall from grace, and he may spend years behind bars. Well, you will be shocked to hear what this next former supervisor of Border Patrol was facing charges for.
I received a call of a female down. She was face down, lots of blood. No, she was brutally attacked.
On April 9th, 2018, Ronald Anthony Burgos Aviles, a former supervisor of the Border Patrol, went on trial for the shocking and brutal murders of Griselda Hernandez and their 1-year-old son, Dominic Alexander.
That morning, more or less around 11:30 a.m., I received a call of a female down by Bristol and Riverbank Road, which is located in Mines Road, with lacerations to her head. While en route to that call, my dispatchers informed me that she was possibly deceased.
Okay. And did you proceed to that area?
Yes, sir. Upon arrival, the ambulance, the City of Laredo paramedics, the ambulance was already parked outside. I parked and I walked down to the trail.
Okay, did you come in contact with anybody when you got there?
Yes, while on my way down, 2 paramedics were on the way up, and I asked them more or less, where is everybody? They said, follow the dirt trail, and you'll see the body and you see the USBP agents down there.
Okay. Did you come in contact with a BP agent by the name of Dennison?
Yes, sir.
More than 20 witnesses, including family members, law enforcement officers, forensic experts, and close friends. Officer Alberto Cortez Jr. took to the stand to describe the horrifying scene he received about a woman down with lacerations on her head.
This is where BP units were stationed. 4 to 5 United States Border Patrol agents were located here. And a motionless, lifeless female body was about right here. She was facing eastbound. And upon me being a police officer, secured the crime scene, to look for any evidence that includes anything out of the ordinary. As I began to canvass the crime scene, in better words, I was walking around this grassy on the edge. There was one USBP agent, Agent Dennison, already ahead of me. He was already south. I passed the female body. I did look at her. I observed she was barefooted. She was face down. Lots of blood. Can you hear me? Yes, lots of blood around her upper middle torso on the dirt. And continuing my path southbound, I saw blood drops on the dirt. At this time, Agent Dennison said out loud, I found another body.
Okay, stop right there.
Okay.
The incident occurred not far from Father McNaboe Park's walking paths off Bristol Road and close to the banks of the Rio Grande. Officer Cortez Jr. described the grim scenes when he discovered the body of the woman lying barefoot and covered in blood.
Is this the type of blood that you saw?
That is correct, sir.
You also said that there was, and you didn't walk on the, where were you walking? Let me ask you that much.
On the grass, where the grass and the dirt meet, right on that.
So you stayed on the
boundary.
edge of the
Yes.
path? You did not disturb the dirt path?
No, sir.
Were you the first officer that arrived?
Yes, that is correct.
You were the first official Laredo police officer to arrive?
Yes.
And this location falls within your jurisdiction?
No. Each officer is assigned a certain area. I got dispatched to be there.
No, but what I'm saying, that's within the city limits?
Oh, yes, that is correct. Yes.
Okay, so this is within the city limits?
Yes.
What county is this?
Webb County.
So the body's in the city of Laredo and Webb County?
Yes.
Cortez recalled getting an urgent call from another officer at the scene shortly after he ensured that the scene remained uncontaminated. To his shock, the officer had discovered something completely horrifying, intensifying the gravity of the situation.
What was your impression of what had happened?
Any prudent person will see a lifeless, motionless body to come to the conclusion that she was deceased.
But at that time, the opinion as to how she was deceased based on what you're seeing, what you're assessing, are you making an assessment?
No, she was brutally attacked.
You also testified that he said that there was a body.
That is correct.
Okay. What happens at that point? Or what do you do at that point?
At that point, he was ahead of me, southbound. When I heard him say, I found another body, I walked towards his direction, to his location. He was no longer on the dirt path. He was in the brush. And when I arrived there at the brush with Agent Dennison, I observed a motionless little boy as well.
Officer Dennison discovered another body of a motionless little boy, who was later identified as Dominic. The officer described the heart-wrenching scene as he saw the lifeless body of a 1-year-old lying on the ground.
What you saw?
Of course. Little brown booties, little brown boy booties, blue jeans that were covered in blood, freshly haircut, and what caught more of my attention was the way the body was positioned, he was placed. He wasn't thrown, he was placed. It's as if someone had placed him down.
Did you see any injuries to the baby?
Yes, lots of blood around the neck area, and that came down. I said again, blood on the blue jeans as well.
Okay. And you recognize this?
Yes, now I remember the t-shirt. Yes, sir.
Did you see any other injuries on the baby? How close were you to the baby?
Standing right over the body.
How many injuries did you observe on the baby at that time?
I only observed one.
That was to
the neck area.
The clothes worn by Dominic were presented to Cortez, who immediately recognized them as the same ones he was wearing the day of the terrible tragedy. It is truly heartbreaking to watch the realization weighing on the officer while the father of the baby doesn't get fazed.
Agent Dennison was in front of you this whole
Yes,
time?
he was with me, yes, sir.
And you were with him when the shoe was found?
Yes, sir.
And what communication came over the radio that morning?
It was broadcasted, possible suspect, Burgos. That was broadcasted over my P unit, portable unit.
What was your reaction at that time? But when you heard Burgos, what did that mean? Did it mean anything to you at all?
No, sir.
Did Dennison?
Dennison was in close proximity where he could hear the broadcast on my radio.
You have your radio.
Yes, sir.
The name Burgos comes out.
Yes, sir.
It means nothing to you.
No, sir.
Do you see a physical change in Agent Dennison?
Yes, sir.
To you, what do you see this physical change?
He was in shock.
Cortez also told the authorities that when he heard the conversation about Burgos being named as a suspect, Officer Dennison was in the area. His reaction, marked with a concerning familiarity, suggested that he was not shocked by the news, but rather that it felt all too normal in the circumstances they faced.
And you saw Mr. Burgos there at the scene as well?
I saw many of them, yes. But sitting here, I recognize him, yes.
And he appeared to be in shock as well as Agent Dennison, correct?
No.
That was not your impression?
No, sir.
So you're saying that he appeared to be normal to you?
Yes, sir.
All right. No further questions, Your Honor.
The officer disclosed a startling fact about Burgos. He showed no signs of shock or even remorse for what he did after he arrived on the scene. Now, this next case is the perfect example of how these cops abuse their powers.
He told me that it moved from the fast lane to the middle lane, to the slow lane, to the middle lane, to the slow lane. Is that correct?
That is correct, sir.
Okay. So, which was it?
On May 11th, 2017, a police corporal in the Fayette County town of Tyrone approached a parked pickup truck during a routine check. To his surprise, the driver behind the wheel was none other than State Senator Marty Harbin, known for his contentious support of the religious freedom measure from past years.
Our policy, over 30 days of expiration, we have to tow the vehicle.
You serious with me?
Yes, sir.
I'll call it. I won't call Eric Dial, but I'll call the rest of them. But I pay my bills. This will not go over well.
I can tell you can talk to everybody at the department. The car's going to be impounded.
The situation got rapidly out of hand, and when he was pulled over by another officer for driving with an expired tag. When he was told that his truck would be towed, he did not comply. The scenario became more intense because of his blatant attempt to use influence.
Because I'm going to take this, and I'm going to the state, and we're going to change the law.
You're not the only one this happens to. So,
yeah, I mean, but I'm just saying
it's not like
law,
we're picking on you.
The law's wrong in that respect.
Okay.
And I'm not mad at
that's
you.
What I mean. We can't change the law. I mean,
I can't.
That's you.
Harbin was shocked to learn that the police officers are able to confiscate cars for anything as little as an expired tag. To modify what he perceived to be an unduly severe punishment for a relatively trivial error, Harbin had introduced a bill aimed at allowing drivers to drive away from expired tag offenses.
It was moving in the fast lane.
Okay. Was there any movement into other lanes?
Yes, sir.
Okay. Tell me about that.
The vehicle moved from the fast lane to the center lane at one point in time. And then from the center lane to the curb lane and then back to the fast lane. And then eventually exited the freeway, sir.
Okay. So when you were following the vehicle, it moved from the fast lane to the center lane to the curb lane, back to the center lane, back to the slow lane. Did I get that right?
Something like that, yes, sir.
Okay.
That'd be close.
Okay, so the vehicle changed lanes.
The vehicle did change lanes, yes,
Okay.
sir.
And then the vehicle exited the freeway.
That is correct, sir.
Okay. All right. Do you remember speaking with me during an interview a little while back?
Yes, sir, I do.
Okay. And you gave me honest answers during that interview?
To the best of my recollection, yes, sir.
Okay. Do you remember me asking you about the vehicle's movement during that interview?
No, sir, I do. I remember you asking the question, but I don't remember exact particulars, sir.
Okay.
During a tense moment in the courtroom, the officer was asked who had stopped the senator. As the lawyer pressed him, it became clear that the cop's story wasn't holding up.
Do you recall me asking, when you were following the vehicle, did it stay in the same lane the whole time?
I know you asked numerous questions. That may have been one of them, yes, sir.
Okay. Do you recall your response?
No, sir, I do not.
Okay. Permission of the court, Your Honor, I would like to play a portion of my interview with Sergeant Pavis where I asked him whether the vehicle, when he was following it, if it stayed in the same lane the whole time.
And Mr. Payne, any objection?
No, Your Honor.
Okay. That portion of the tape, Mr.
And just going backwards a little bit, okay. When you were following the pickup truck, did it stay in the same lane the whole time?
Yes, it did.
Okay.
When we got closer to that.
Did you hear that, Sergeant?
Yes, sir, I did.
Okay. So when I asked you, did the pickup truck stay in the same lane the whole time, your answer was, yes, it did.
That is correct. That is my answer.
The lawyer skillfully exposed the lies in the officer's testimony by playing a video of the cop's previous interview regarding the incident in court.
And just before I played that, when I was asking you about whether the pickup truck stayed in the same lane while you were following it, you told me that it moved from the fast lane to the middle lane, to the slow lane, to the middle lane, to the slow lane. Is that correct?
That is correct, sir.
Okay. So, which was it?
When I was behind the vehicle, I was in the fast lane the whole time. And at some point in time, as I just mentioned to you, he did move from lane to lane, sir.
Okay. So you don't find anything inconsistent with what you told me here in court and what we talked about?
I could see where you would see that as an inconsistency, yes, sir.
Okay.
The officer was left completely speechless as the lawyer skillfully proved him a liar in court. Each pointed question seemed to damage his credibility, and by the end, he had nothing to say in his defense. This next cop was not owned by a lawyer, but by a judge.
Then I want you taking him up on perjury.
Your Honor.
Will you take him up for perjury?
He admitted it was a mistake, Your Honor.
No, but he lied. He lied on a sworn
Absolutely
citation.
not, Your Honor, and that is...
46-year-old Lisette Gonzalez was charged with DUI. However, it was discovered during her trial that the arresting officer had not used a breathalyzer test. The judge was outraged by this wrongdoing and instantly reprimanded him.
I want to be enlightened.
It was a mistake, admittedly, by Michael Wagner.
I know.
He testified to that today.
He caused her to have her driver's license suspended for at least a few months for nothing. So are you going to no process that case, or am I going to get mad at you today?
Perhaps you can get mad at me, Your Honor, but at this point...
Why wouldn't you? Wait a minute. Did you hear the uncontroverted testimony of this officer?
Your Honor.
Then I want you taking him up on perjury.
Your Honor.
Will you take him up for perjury?
He admitted it was a mistake, Your Honor.
No, but he lied. He lied on a sworn
Absolutely
citation.
not, Your Honor, and that That is not true.
I'm dismissing. I'm dismissing. I am dismissing this charge. No, I'm dismissing the charge. This whole case was fishy, and I have no idea how they. You know what?
Their address on file.
You know what?
The state intends to amend
I'm
the
granting.
charge and proceed on
I'm rescinding the sentence. I'm granting the JOA.
So you're granting it because you don't agree with the state's decision on
I'm
the
granting
other
the JOA in fairness.
charge? In fairness, because you don't like the state's decision today, Your Honor, on the case?
No, you're not. Now that I consider what Officer Wagner testified to and how many times he basically tripped over himself just to arrest this lady with no real probable cause. You're done. Motion, the JOA is granted.
And you're not going to provide a written order on that?
Nope. You want to appeal me? Appeal me.
Thank you, Your Honor.
The case should have never been done. Never.
Thank you for letting us know that, Your Honor.
Next, watch how this tyrant was punished for his actions in court.
Let's get him on the opposite side of this truck.
Let's go over here, sir.
Cody? Let's go on the opposite side.
Sir, let's walk over here.
Why is that? That's messed up.
Let's walk over here.
Sure. That's what I'm saying. Let's get him on the opposite side of this truck.
And the court left the door open.
For me, not for you.
Evil cops often believe their badge grants them immunity from justice. But when their crime catches up to them, the courtroom becomes their ultimate reckoning. Today we'll be going through cases where corrupt cops face their darkest hours. In 2017, a series of troubling events unfolded about Sheriff James Lujan's assistance to a friend and former city councilor, Phil Chacon, in his attempt to escape law enforcement during a police pursuit. The officers arrived at the facility to take Sheriff Lujan into custody.
Stack up on the front. Towards the phone. Hold it, go to. Stack going.
Morning, sir. Executing search warrant. Sheriff Lujan.
Search warrant for him or?
For the building as well.
For what?
I have no idea. It's house. But no, just stay here. No, I can't have you enter the scene.
You guys are fucked up, man.
Why are they beating on things?
You guys want to put him...
Let's get him on the opposite side of this truck.
Let's go over here, sir.
Cody? Let's go on the opposite side.
Sir, let's walk over here.
Why is that? That's messed up.
Let's walk over here.
Sure. That's what I'm saying. Let's get him on the opposite side of this truck. Well, you got Tabitha over there. Right yet. I got the press out here taking pictures of me in handcuffs.
The sheriff was shocked by the circumstances and felt he had too much right to be the target of a search like this. To get him to cooperate with the search, deputies had to use their authority.
Push him around into the doorway. Yeah, push him around into the doorway. At least to the doorway. This is ridiculous.
Keep him up there.
Hold on, we have press.
Keep him up there.
Come over here, sir.
Keep him up there.
Sheriff,
Go.
what are you doing?
Stay out here. Ah, Jesus. Really?
You don't have to.
Look
just
here,
stand.
look behind
just
you.
stand. Just stand.
Stand up, stand up. Put him on this side of the truck. Put him on the outside of the truck.
It hurts. They're loose, sir. They're loose.
No, they're not loose.
They're not even.
Sheriff, those are loose.
So I'm going to read a stipulation.
Can you take these handcuffs off? They hurt. They hurt. Am I under arrest?
You're being detained.
Well, yeah. Why do I have to have cuffs on? They hurt.
The sheriff was advised by the deputies that he was the subject of an active search warrant. When the sheriff realized how serious the issue was, he refused to cooperate and insisted on speaking with his lawyer before taking any more action.
25, 21 units, make sure you guys stay running hot.
So on this, This is signed by a district court judge. Okay. Judge Bowman. Okay. First judicial. Okay. So this search warrant gives me the authorization to seize your phone. Okay. Search your phone. Okay. But it also gives me the authorization. So what I'm asking for you to do is unlock your phone, unlock it, give it back to me, and I'm going to remove the security settings. I don't want your passcode. I'm not asking for your passcode. I'm asking you to unlock the phone. Per the search warrant, you can read it if you want under number 2.
I will if I get a chance to talk to my attorney.
It doesn't work like that.
Marty,
this is not a negotiation.
get off.
This is not a negotiation, Sheriff.
Given how many warrants he probably handled in his career, it is astonishing that a sheriff would not know how a warrant works. He refused to comply with the deputy's request, which resulted in his arrest.
You can talk to your attorney when this is all done. When this is all done, you can call your attorney. But right now, we're trying to get you to comply with the warrant. The warrant stipulates exactly what we want. You give us that, we'll get the phone, we're out of here. That's it. What do you want to do, Sheriff?
Right now, I'm under arrest. Because I am under arrest. I am in handcuffs. I'm not free to leave. I'm not free to leave? Am I free to leave? No. Then, if I'm under arrest, I have a right to an attorney, correct?
You do.
Okay.
And I'm not questioning you.
I'm invoking my right to an attorney right now.
Okay.
You understand that?
So, take him in.
Book me for
booking. For obstruction. Obstruction.
Booking. I'm not obstructing.
Take him over here to our unit. Take him over here to our unit.
Over here, Sheriff. Over here.
Sheriff.
Just...
They're gonna book me.
Really?
Look at this shit. Look.
Stop. Just walk up. Stop, Sheriff. What are you doing?
The sheriff faced public humiliation right outside of his own office. Instead of giving up his phone to the officers, he chose to be handcuffed.
I'm telling you what the warrant stipulates.
I understand that. And
I told you what the warrant stipulates. You had every opportunity to cooperate. You want to cooperate, you're going to jail. Have a seat, sir.
All right, you guys. Why is already
Take the whole thing off. No, I haven't been searched. Just take me so we can do it.
I want to make sure you don't have any knives.
I don't have any knives. I don't have any weapons. That's my wallet.
What's it?
My keys to my truck. I don't have any weapons. Okay? I really don't. You took my weapon. As a matter of fact, you left it on the back of my truck over there. Did you get somebody to secure it, please?
We'll secure everything for you. Now this.
Can you move these to the front?
No, sir. Against department policy.
Well, it's tighter than hell. They hurt.
Sheriff, those are very, very loose.
Really?
Step out. Let me see if I can fix it. They're very, very loose.
His arrest was not taken lightly by the sheriff's colleagues, who started threatening the Santa Fe deputies. Tensions between the two departments were only heightened by the fact that they were arresting their own sheriff while on Rio Arriba territory.
That's his mag, and then we're gonna get you his sidearm.
Get everything. I don't want part of it.
What do you mean everything?
Everything.
So this is what we took off this person? You're the one that took it off this person?
Took it off this person.
Deputy Graves.
Well, inventory before you get it.
We're handing it right over to you.
Inventory. Can't get away from me. Look what you guys are doing.
We're trying to do everything peacefully. We tried to. Okay? That's all we're doing. We're done here. We're leaving.
Okay, well get out of here then. You're done. Get out.
We'll leave when we're ready.
You said you were done.
Yeah, we're wrapping it up right now. You know how it goes. You know how it goes. We're doing our law enforcement duties. That's it. District court signed it. That's it.
Okay.
Okay, so as soon as we're done, we're gonna get out of your hair. Why are you calling everybody here to put them involved?
Our house.
Well, right now it's ours. Right now it's ours.
Oh, wow. We own the building right now.
Shut up.
Don't talk to me like that.
Shut up.
Hey. I don't work for you. Don't talk to me like
Shut
that.
up.
Easy.
Get that and let's go. Are we done in there? Are we done in there? Okay.
The sheriff was taken straight to the police station for further questioning by the deputies, who refused to back down despite the mounting pressure.
I have no idea, sir. You find out from her? You go ask her. Well, this is your house. You go ask her. Oh, no. Yeah, it is now. Because we just gave it back to you.
This gets hurt. God.
The sheriff was ultimately accused of 2 felonies, helping a victim and intimidating a victim. When the case went to trial, the judge gave a harsh verdict, holding the corrupt sheriff completely responsible for his deeds.
The people of Rio Arriba County elected you to be sheriff. They put their trust in you to uphold the law, and you let them down.
Yes, Your Honor, I try to do the best that I can to help everybody I can, and I in no way would want to.
The law is the law. You are not above the law, nor can you ignore the law when it serves your purpose. The sentences will be served consecutively for a total of 4.5 years, of which 3 years of imprisonment and 1.5 years supervised probation. You let down the people of Rio Arriba County, and you let down the Sheriff's Department, the department that you led. What kind of example were you giving the people that you supervise?
He resigned as sheriff 1 day after being found guilty and was sentenced to a 3-year jail sentence. This next officer did not care about his actions, even in the presence of an 8-year-old.
It's the jury having found you guilty of the offense of manslaughter and assessed this punishment.
Dean was initially charged with the murder of Jefferson. However, the judge told the jury that they might also consider a manslaughter conviction prior to the panel's deliberation. A manslaughter conviction in Texas can result in a maximum sentence of 20 years in jail.
Verdict reads, we the jury, having found the defendant Aaron York Dean guilty beyond a reasonable doubt of the offense of manslaughter, assess his punishment at confinement in the Texas Department of Criminal Justice for 11 years, 10 months, 12 days. They do not assess a fine. And it is signed by the presiding juror. You may be seated. Thank you very much. Members of the jury, as we went through before, I'm going to call your juror number and ask you if this verdict is your individual verdict. Juror number 1, is this your verdict?
Yes, Your Honor.
Juror number 3, is this your verdict?
Yes, Your Honor.
Juror number 4, is this your verdict?
Yes,
Juror number 6, is this your verdict?
Yes, Your Honor.
Juror number 9, is this your verdict? Juror number 14, is this your verdict?
Yes, Your Honor.
Juror number 15, is this your verdict?
Yes, Your Honor.
Juror number 21, is this your verdict? Juror number 31, is this your verdict?
Yes, Your Honor.
Juror number 32, is this your verdict? Juror number 37, is this your verdict? Juror number 38, is this your verdict?
Yes, Your Honor.
Your verdict will be received and filed. Thank you very much.
The main question at trial was whether Dean knew Jefferson was carrying a weapon. In his testimony, Dean claimed to have seen her weapon, but the prosecution said that the evidence did not support this claim.
It's the jury having found you guilty of the offense of manslaughter and assessed this punishment. It's the order of the court you be remanded to the custody of the sheriff, be delivered to the director of the Texas Department of Criminal Justice to serve your sentence as required by law. You will receive credit for all the time that you have served in custody on this case from the date of your original arrest up until today, which would be the date of sentence. You have the right to appeal the jury's decision. You do so by giving written notice of appeal to the Second Court of Appeals here in Fort Worth within 30 days. If you are indigent and cannot afford a lawyer, I would conduct an indigency hearing to determine if you are indigent. And if you are indigent, I would appoint a lawyer to represent you on appeal and provide you a record of this appeal of this trial at no cost. Mr. Gill, Mr. Brissett, if y'all will remain on his case pending his decision whether he wishes to appeal, and if you'll furnish the information for the trial court certification of appeal before you leave here today, I would appreciate it. Is there an allocution? Yes. You may be seated. Thank you very much.
The cop received a sentence of over 12 years in jail after being found guilty of manslaughter. Later on, a $3.5 million settlement was also approved for the boy who saw his aunt getting shot to death through her home's window. The saga of evil cops just doesn't end here. This next officer didn't hesitate to shoot a schizophrenic patient. On January 15th, 2020, employees at an AT&T shop on Main Avenue reported a client yelling at workers and brandishing a knife, prompting Norwalk police to come to the scene. When he was asked to leave, the man tried to take a cell phone, but the clerk was able to get it back from him. Solomon, the suspect, reportedly called for a ride-sharing service, argued with the driver, and then slapped him. When the driver got out of the vehicle, Solomon stole the car, and that's when the police initiated the pursuit.
Visual left off 43.
Get out of the car! Get out of the car! Jackson! Go to taser! Taser! He's got a knife! Drop the knife! Drop the knife!
Solomon was chased by state police on I-95 North from Norwalk into West Haven, where he collided with multiple cars and police cruisers. When he pulled onto the exit 43 ramp and stopped under the Campbell Avenue Bridge, the chase came to an end.
It's out of his hands, it's on his lap. I got the knife. It's on the hood. Pull him out. Jackson, go to taser. Taser.
While the police officer yelled orders, a trooper smashed the car's window and retrieved the knife. From another angle, it becomes clear what the trooper did next, an action that will leave you in complete shock.
He's got a knife. Drop the knife. Drop the knife. I got the knife. It's on the hood. Pull him out.
According to Trooper Brian North, he fired to defend other police officers. However, the state's inspector general concluded that the gunshot wound was not justified. Brian's trial started on March 4th, and here is what happened in the trial. When North testified on March 8th, 2024, he said in his testimony that he shot Solomon because he thought that the lives of fellow officers were at risk. What is interesting is the fact that this cop thought that a group of armed police officers could be harmed by a 19-year-old with a knife.
Now, sir, you were asked a series of questions about you firing your weapon in this towards Mr. Suleiman. Please describe again why you fired your weapon that day.
It was to protect the West Haven officer and Trooper Jackson from the threat of imminent death or serious physical injury.
And you were just shown a series of still photographs that included Trooper Jackson's body-worn camera. Do you recall seeing those?
Yes.
And again, your decision to use force the way you did was based on what?
It was based on what I was perceiving at the time.
During the trial, the lawyers kept delving deeper into the circumstances surrounding Soleiman's death, relying on video footage and police department testimony for further examination.
Who was in charge?
There was no one person in charge.
And who made the decision to break the passenger side window?
It was a West Haven officer, Officer Rappa.
Did that decision change the overall situation?
Yes, once the glass of the window was broken, Mr. Suleiman, it startled him, and the situation, he rapidly escalated it.
Prior to the breaking of that window, what was Mr. Suleiman's state?
He appeared to be unconscious and unresponsive.
We watched a video of you interacting with Trooper Richter and Sergeant Kiley. Do you recall that?
Yes.
The prosecution argued that North's early remarks after the shooting were contradictory, as the officer ordered Suleiman to drop the knife completely, ignoring the fact that he shot Suleiman 7 times.
So we're not trained to reassess after each shot. We're trained to reassess after each use of force, which would be an engagement. So that brief series of shots you would then reassess after that.
And Attorney Devlin had asked you, if I'm quoting correctly, did you fire as many times as you wanted to? My question is, how many times did you want to?
There was no number. It was just whatever I thought was necessary to stop the threat at hand.
And then you use the term reassess. At what point would then you have the ability to reassess?
Immediately following shots being fired.
You were asked questions about the fact that you shot through glass, correct?
Correct.
What impact does firing a weapon when shot through glass have on the shot?
Objection, no foundation.
The cop clearly replied that he isn't trained to assess the situation after shooting. He also explained that his response was influenced by the information given to them that Suleiman was armed and involved in a carjacking.
That if that West Haven officer was not going through that window, but was standing outside as is shown in the video, it would not be objectively reasonable to shoot that gun at Suleiman, right?
Objection, Your Honor, that's speculation.
He's asking, he had him read the state police criteria there, and I'm asking him if no one's going into that car, it's objectively unreasonable to shoot the driver.
Can we just do it one step at a time?
Sure.
When the officer asked him if using the gun was an objectively reasonable response given the situation, the officer remained silent. He was unable to defend the use of deadly force above de-escalation.
Is he guilty or not guilty of the lesser included offense of criminally negligent homicide in violation of Connecticut General Statutes 53A, 55, with which he stands charged?
Not guilty.
Does the court accept this verdict?
Yes.
The jury may be seated. Ladies and gentlemen of the jury, please listen to your verdict as it is accepted in order recorded by the court. You, ladies and gentlemen of the jury, each of you do say unanimously that the defendant is not guilty of the crime of manslaughter in the first degree with the firearm in violation of Section 53A, 55, paren A, paren 3, and Section 53, 55A of the Connecticut General Statutes as outlined. You, ladies and gentlemen of the jury, each of you do say unanimously that the defendant is not guilty of the crime of the lesser included offense of manslaughter in the second degree with the firearm in violation of Connecticut General Statutes 53A, 56, paren A, paren 1, and section 53A, 56A of the Connecticut General Statutes as outlined. You, ladies and gentlemen of the jury, each of you do say unanimously that the defendant is not guilty of the lesser included offense of criminally negligent homicide in violation of section 53A, 55 of the Connecticut General Statutes as outlined.
The Milford jury found Trooper Brian North not guilty on all counts by a Milford jury, in spite of a strong popular disapproval and conviction that he was guilty. Following 2 weeks of testimony and several days of discussion, the jury gave a verdict that ended the trial. Now, while this cop was let go easily, this next judge did something completely unexpected in the courtroom.
Before the Don't get brazen with me.
During a night of chaos in Kenosha, sparked by the police killing of 29-year-old black man Jacob Blake, who was left paralyzed after an altercation with a cop, Rittenhouse armed himself with an AR-15 style gun. As things got quickly out of hand, Rittenhouse opened fire, killing 36-year-old Joseph Rosenbaum and 26-year-old Anthony Hubert, in addition to wounding 26-year-old Gage Grosskreutz.
You indicated that at no time did this gun, this AR-15, ever leave the state of Wisconsin. Is that right?
Other than the night after, other than that.
Before the shootings?
Correct.
There was a time, though, where you wanted to have it with you down in Illinois, isn't it? It wasn't there?
I believe there was a time when me and Dominic were mad at each other. Yeah.
You were mad at Dominic?
Me and Dominic were mad over something.
And you wanted to have the gun with you down there?
I think I said something along those lines.
You'd agree with me that... Let me back up for a second here. You have testified to this jury that you used deadly force against Joseph Rosenbaum, Anthony Hubert, the man who attempted to kick you in the face, and Gage Grosskreutz on the night of August 25th, correct?
Yes.
And you did that because you felt that your life was in danger from those four people, correct?
Yes.
And you are telling this jury that it was, in your mind, justified to use deadly force to protect your own life, correct?
Yes.
Many of the most contentious topics of the country are addressed in this case, such as vigilantism, self-defense, the Second Amendment, violence during racial justice protests, and the different perceptions of how the legal system and law enforcement handle white people and people of color.
You'd agree with me that you were not allowed to use deadly force to protect that CarSource building, correct?
Well, I wasn't using deadly force to protect the property. I used deadly force to protect myself, so...
Please listen to my question and answer my question if you can. You'd agree with me that you were not allowed to use deadly force to protect that CarSource building, correct?
Yes.
You'd agree with me that you were not allowed to use deadly force to stop someone from smashing the windows of an unoccupied parked car, correct?
I don't think you could use deadly force for that.
You'd agree with me that you can't use deadly force to stop someone from lighting a metal dumpster on fire, correct?
Correct.
You'd agree with me that you can't use deadly force to stop someone from tipping over.
Correct.
You'd agree you can't use deadly force to stop someone from lighting a flatbed trailer on fire, correct?
Correct.
You'd agree with me that you can't use deadly force to stop someone who is about to start an unoccupied car on fire, correct?
Prosecutor Thomas Binger was accused by lead defense lawyer Mark Richards of disobeying earlier decisions and trying to provoke a mistrial. However, tensions in the courtroom increased as Binger replied and prompted an unexpected response from the judge.
Mr. Richards? Your Honor, Mr. Binger is either forgetting court's rulings or attempting to provoke a mistrial in this matter. He knows he can't go into this, and he's asking the questions. I asked the court to strongly admonish him, and the next time it happens, I'll be asking for a mistrial with prejudice. He's an
First of all, Your Honor, this was the subject of a motion. I'm well aware of that. And the court left the door open.
For me, not for you.
My understanding of
You should have come and asked for reconsideration. You did on the one motion, and in fact, I granted your motion for reconsideration.
That was not our motion.
Excuse me. I did. I granted.
We did not move
that
to
was
reconsider.
their motion.
We have not filed any
me.
motions to reconsider in this case.
That was their motion for reconsideration, which I denied. But I said I denied it, or I indicated a bias towards denial is what I did.
When prosecutor Thomas Binger implied the court had allowed for specific lines of interrogation, including those he pursued with the defender, the judge dismissed the jury and became enraged.
Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, well, I'll leave it at that. So I don't know what you're up to.
May I respond?
Yes.
We filed an other acts motion on this exact issue because, in my mind, and I argued this, it is identical to what was going on the night of August 25th, in the sense that the defendant was using this exact same weapon. He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect...
I'm not going to rehash the motion. Yeah, that's absolutely untrue. No. Your argument's of record. My comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest anything's changed, even if you're correct in your assumption that you know more than I did at the time.
What came next was extensive verbal attacks aimed directly at the prosecutor. According to the report, the prosecutor's strategies in the past have contributed to worsening these serious issues in high-profile cases.
May I finish, please? I'd like to have a chance to make a record, if I could, without being interrupted, if that's okay. He has mentioned that he's acknowledged that he's used this gun to protect property. He's also just acknowledged that he knows he can't do that. I am attempting to impeach him now with the prior August 10th incident, 15 days prior, involving the same gun, where he is threatening to use that gun to protect property. It goes...
He has the gun with him.
Your Honor, he is saying he wished he did so he could shoot people.
You know, there's a lot of difference between commenting about something when you haven't got a gun and threatening someone when you do.
You know, it's interesting, Your Honor, because the entire defense theory in this case is Joseph Rosenbaum, who was unarmed.
I want you to tell me what the defense theory of the case is. May I
respond to what you just said, Your Honor? I'd like to respond to what you just said. I apologize, Madam Court Reporter, but I'd like to try and make a record without anyone interrupting me, if that's okay.
Binger, however, kept his cool and claimed that he had filed an other acts petition to provide evidence indicating that Rittenhouse said that he wanted to use his weapon to protect property rather than people.
I've admitted that kind of evidence in other trials when it's been appropriate. I didn't admit it in this case because, to me, what I've heard in this trial, and by the way, Mr. Richards absolutely correctly points out that just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the defense testimony.
Don't get brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that. That's number one. Number two, this is propensity evidence. I said at the time that I made my ruling, and I'll repeat again now for you, I see no similarity between talking about wishing you had your AR gun, which you don't have, so that you could fire rounds at these thought to be shoplifters, and the incidents in these cases, which are not... There's nothing in your case that suggests the defendant was lying in wait to shoot at somebody.
Judge Schroeder lost his cool with the prosecutor, but in doing so, he mischaracterized the case and was not corrected. The prosecution said that Rittenhouse was the one who started the altercation and provoked the people he shot.
When you were I said you were over the line and close to or over the line on commenting on the defendant's pretrial silence, which is a well-known rule. I'm astonished that would have been an issue. So I don't want to have another issue as long as this case continues. Is that clear?
It is.
Thank you. Ask the jury to come back in, please.
However, Rittenhouse faced numerous charges that included first-degree reckless homicide, use of a dangerous weapon, first-degree endangering safety, first-degree intentional homicide, possession of a dangerous weapon, and first-degree recklessly endangering safety. Well, that brings us to the end of today's video. Today we saw the shocking reactions of evil cops facing life sentences in the courtroom. These individuals, sworn to protect and serve, instead chose a path of corruption and violence, and now they're facing the consequences of their actions. Justice is finally being served, and it's a reminder that no one is above the law. And if you agree, please consider showing your support by liking this video, and don't forget to subscribe to stay updated on more cases like these. Also, if you enjoyed this video, check out the next video right here.